Relatives own property or doing business. I represent two major health supplement companies, and they distribute. First of all, their source of some of their product is offshore, and then they distribute offshore. So they're logical candidates to have an offshore structure. Let me tell you another couple of instances where you might want an offshore structure that are a little bit of exceptions to this. Some people really want to protect their IP, their intellectual property, and they're worried about privacy, and they're worried about having to disclose some of their intellectual property and having it challenged. So we have set up structures offshore to hold title to the intellectual property. And for example, somebody gets a, they have, we just had a client and they have certain, they have a software program that gives them access to certain client information. And they're worried about being forced to disgorge that information from a standpoint of privacy. So we've set up an offshore trust that owns an offshore entity, and we place the intellectual property into that offshore entity so that it's beyond the jurisdiction of the U.S. courts. So that's another area that might be relevant. Another situation that you could do is also import and exporters have, they have definitely, that would be the doing business offshore by importing or exporting. So they might create an offshore company that is a distribution company or an importing company and to the American side. And they would use that, they would have that company owned by an offshore trust and to give further protection. And that company charges the American company fees. And it's beyond the scope of this class to go into all of the international tax ramifications. Basically, let me just say this. Offshore corporations are, any income that they earn, they're normally foreign-controlled corporations. And therefore, the income earned by the offshore corporation has to, the owner of the foreign corporation, whoever is deemed to be the owner, has to pay tax on that, whether it's distributed to them or not. So if you have an offshore company that, let's say they have a couple of $1 million in an LLC, and it earns the interest on that a couple of $1 million, ultimately the client's going to pay tax on that. And if they're in a business, they have to own, they can't own more than 50% of the stock of the offshore company. Or otherwise it's a foreign-controlled company and they have to pay taxes on, they can't accrue income in the corporation. It also has to be managed outside the United States to be a legitimate non-foreign controlled company. So you need two factors. You need 50% or less by American ownership, and you need offshore management in order to be able to accrue income in the company. And what happens is you choose a jurisdiction that is tax-free for an international company, so that you get a situation where there's no tax at all paid. Not any in the jurisdiction of the company and not in the United States, because it's a non-foreign controlled company. So it can be a terrific way of saving taxes, but you just have to play by the rules. And it's going to be audited, and you have to be very careful